Welcome to the Iowa Court of Appeals. We're set to hear three cases in this 9 o'clock session. The first of those is 25-0503, Clemen versus Dolgencorp, or Dollar General. We have Bruce Toenjes for the appellant and John Maschman for the appellee. Whenever you're ready, Counsel.
The court staff, counsel, this case is not about holding a business liable for every crack in a city sidewalk. This case is about a business that knew of a dangerous condition directly in front of its only entrance, knew its customers would have to encounter that condition when entering the store, affirmatively acted to force them to encounter it, and then chose not to warn or protect them. This case is about Dollar General's independent common law duties to protect its customers and to warn its customers from a known danger. The district court made two errors of law. The district court erred in concluding that Dollar General had no common law duty to warn and protect its customers of a known danger that it knew they would encounter. And second, the district court erred in concluding Dollar General did not create the risk by its own conduct on its own property, funneling customers over the dangerous condition and failing to warn or barricade it. This court reviews for errors of law. The factual record must be viewed in the light most favorable to Mr. Clemen. In negligence cases, duty is a question for the court, and the remainder of the issues on negligence are for the jury. The Supreme Court held in Thompson and in other cases that in most all cases, the duty of reasonable care exists. This court applied that rule in Hoyt, which Your Honor authored, and which the Supreme Court then affirmed. Hoyt involved much more challenging facts on the duty question than are presented in this case. Yet this court found a duty, and the Supreme Court found a duty. In Hoyt, the Supreme Court said that no duty determinations should be limited to exceptional cases where there is an articulated countervailing policy. So for Dollar General to prevail, this court must find that there is no potentially viable duty of care, viewing the record most favorably to Mr. Clemen.
Could you talk about how that duty issue was raised below and whether all the arguments raised on appeal about special duties were presented to the district court?
Absolutely. The first, starting with the petition asserts a duty to warn. The petition asserts duty to protect. Then, obviously, also the petition alleged the statutory duty that was eliminated during the pendency of this case by Split Gerber. And then we raised the issue in the Statement of Undisputed Facts. We raised the issue in our brief specifically before the court in the Memorandum of Authorities. We raised it in the argument, but the argument isn't reported.
Specifically, you talk in your brief about restatement section 40. I did not see that addressed in the district court ruling. It looks like the court focused more on sections 54 and 18. So can we consider restatement section 40 on appeal?
Yes, I thought the court did address 40. The court certainly addressed Hoyt, which is based on 40. I can look back before my rebuttal, but I thought it was addressed, Your Honor. So, once we get past the duty question, the liability issue, the facts are essentially undisputed. So, with respect to the first area, Your Honors, Dollar General wants you to decide that Split Gerber versus Bankers Trust eliminates all duty with respect to defective sidewalks. That is not the holding of Split Gerber, and this case is fundamentally different from Split Gerber. Split Gerber only eliminated statutory duty and liability for sidewalk maintenance under section 364.12. It did not erase common law duties to customers. And in response, partly in response to your question, Your Honor, the district court did not rely on Split Gerber in its decision. It instead relied on this question of what is the risk specifically, and it conflated the broken sidewalk with risk from failure to warn or failure to protect. Split Gerber did not eliminate common law duty with respect to failure to warn or protect, especially when the defendant knows of the risk and there's a Section 40 special relationship. Now, Split Gerber did not involve a known dangerous condition, and there was no special relationship under Section 40 in Split Gerber. In fact, it involved a pedestrian who, according to the first sentence of I think it's Justice McDermott's opinion, said was out for a stroll. It did not say they were going to Bankers Trust to do business. He made a point of that.
Differentiate that kind of situation. How do we know if someone's going to be a customer or if they're just a passerby, if they like last minute decide to go in a store? It seems like a kind of tough factual distinction.
It's a factual distinction that has to be made in the record, and then the court has to decide. The legislature can change that if they want to make the duty expanded to individuals. And in fact, I think that was the point of the dissent in Split Gerber. You've had 10 years since Madden. Why didn't the legislature do something? Because it's a statutory issue, and we shouldn't be overruling or using, overruling cases, and we should be respecting stare decisis when it's a statutory issue and the legislature can decide. But that's the fact of it. I mean, that is what happens. We have the record. And in this case, the record is my client was a customer, was going into the store, and actually the defect was so close to the store and abutting the store that when he lost his footing on the defect, he landed on Dollar General's property, and his injury was when his hand rammed into Dollar General's automatic sliding glass door. So you don't have to decide a different case, Your Honor. You can decide this case on these facts. Now, Dollar General knew of this hazard, and on May 10th of 2021, its manager reported to the corporate that there was, quote, a very bad spot in the sidewalk directly in front of the entrance door. And then their response was to delay repair due to volume of requests for repair. On June 11th, store management told corporate it was a very big safety concern. So Dollar General did nothing to address that. In fact,
Could they have?
could they have? Absolutely.
On city property, rip up concrete, and then re-pour concrete out of their own pocket on city sidewalk?
They did do that eventually, and that's in the record. But number two, they have the duty to do that. They have the duty to the city. And Split Gerber makes it clear that there's no longer duty to a passerby from a defect in sidewalk. But it says specifically in Split Gerber that the city can still enforce its duty, the duty to maintain the sidewalk. It just eliminates the financial liability to a third party. So, and I think it's important too, Your Honors, that Hoyt tells us that all risks must be evaluated all risks created by an actor's conduct or course of conduct must be evaluated in determining whether there is a duty. So it's not just one particular risk. As to the second error, Your Honors, Dollar General did more than a failure to repair or the city sidewalk. It affirmatively acted on its own property to create risk. Now, it placed merchandise racks on good concrete on each side of the door that funneled the customers in over so they had to encounter the bad concrete. Now, after the fall, they did three things. Dollar General moved the displays. It painted warnings, that's two things, but that shows three things. One, it shows they had control. Two, it shows that the burden of warning and protecting was minimal. And three, Dollar General's conduct on its own property created the risk of harm, and that falls squarely within Section 54. So remember that Hoyt says that all risks have to be evaluated. The district court recognizes that in its opinion, and it says that Dollar General's acts arguably exacerbated the overarching risk to patrons entering the store, but did not create the risk related to the damaged sidewalk. And then the court said it declined to extend liability in this case. That's not an extension of liability. 54, an existing law, does not extend liability. And before 54, the court, the Iowa Supreme Court had recognized a predecessor in Restatement Second. So this isn't some new concept, Your Honor. Dollar General's conduct on its own property made the risk of harm unavoidable. Thank you.
Good morning. May it please the court, counsel. My name is John Maschman. I'm appearing on behalf of the appellees, the Dollar General defendants in this case. This appeal really turns on one question, whether a business that neither owns nor controls nor created the city sidewalk or the defect on the city sidewalk owes a duty to protect or warn those who may use it. The district court answered the question in the negative. We believe that was the correct outcome and should be affirmed. The ruling of the district court sits squarely within the Supreme Court's decision in Split-Gerber that was decided last year. Dollar General did not build this sidewalk. They did not control it. They couldn't legally repair or close it without the permission of the city. The city of Clarksville owned that slab. They carried the statutory duty under Section 364.12. This defect existed before the store was built. It was unchanged when Mr. Clemen fell over it.
Liability that remains for landowners of abutting property?
Yes, we would say that there are, the general rule, as I have articulated it, is that there is no liability if you don't own it. The liability rests with the city. However, there are exceptions that are discussed in the restatement sections that have been adopted by the Supreme Court or otherwise ratified by the legislature. Those are instances in which the conduct of the business owner perhaps projects something onto the public way or otherwise creates a hazard such as like an old awning that might fall upon the public way, or scooping snow and ice in such a way that creates a hazard. But it requires sort of an affirmative act or some sort of conduct on the part of the business owner.
Here doesn't fit that?
We would argue that the funneling does not fit that. The funneling is passive as compared to for instance, water or snow being projected onto the public way. Additionally, we have affirmatively taken the position that the funneling is a bit overstated. Your honors can look at the pictures and decide for yourselves whether this created a funnel of sorts. We believe that you don't have to accept the facts as presented by the appellants, given that you have pictorial evidence, and you don't have to adopt what would essentially be a fiction if you, in fact, find that there was not the degree of funneling or creation of a hazard that the appellants have promoted.
A factual question?
It would be if we were considering perhaps the breach angle or the causation angles, but really this entire case turns on the duty question, and Split-Gerber has answered that question for us, that duty follows control. The Dollar General here did not have control over this slab of sidewalk, and therefore liability cannot attach. So to the extent that there is a fact question on another factor of negligence, I would submit that that's not what is dispositive here, the duty question.
Go hand in hand with the duty to fix the hazard? Because it seems like in this record there's plenty of information that Dollar General had noticed that this was a hazard.
I'm sorry, could you repeat the question?
Warren, is it treated identically to duty to fix what you don't own, I guess?
I feel like both parties have been essentially conflating that. I have not, considered them to be separate buckets of responsibility. Essentially, if a duty attaches, that could be to warn or to fix or whatnot, and we're simply of the position that that duty does not attach under these circumstances. In Weber v. Madison, the court said that a budding owner must not create a hazard in the public way, but has no duty for conditions it does not control. I think that is the set of facts that we have before us currently. The city owned and maintained the sidewalk. As I mentioned, although they eventually remediated matters, it's my understanding that this was sort of with the permission of the city. They don't own this piece of property. Dollar General does not own this piece of property, and therefore their control is cabined by what the city would allow them to do. The appellant's argument essentially turns on our knowledge of the hazard, that our mere knowing of the fact that there is a hazard in front of our store creates some sort of obligation. That's not what the law says. Mere knowledge does not create an obligation. All of the restatement sections cited by the appellants, all of the case law are distinguishable from these facts because there was some affirmative act or, for example, a trampoline blew off of someone's property. These are affirmative acts that occur as opposed to the mere the passive placement of signage.
We weren't dealing with cracks in a sidewalk, but instead a big hole in the sidewalk right in front of the store that the city knew about and didn't do anything to warn customers entering the store. Would the same analysis apply? Would we be saying there's no duty to warn in that situation?
I think it would. Much of the appellant's arguments can turn on the fact that this would have been a relatively simple fix. It would have, and then they point to subsequent remedial measures that were relatively cheap, using spray paint or otherwise grinding down the area. And I think that's a bit of a red herring about the simplicity of the fix. Like, yes, if there were a sinkhole right in front of the Dollar General, I think the analysis would be the same. The size of the hazard is the city's problem and not Dollar General's problem. And that, that may not sit well with with you, but I believe that the people upstairs have answered our question as to where the line is drawn, and that is at the property line. And therefore, the nature of the hazard that sits on the adjacent property is somewhat irrelevant for determining duty under these circumstances.
But Gerber, that it was just a passerby, and in this instance, we have a customer who's aiming to come into the store. Does that relationship make a difference?
Essentially, no, because I think it would be a difficult task of line drawing to determine when and how someone who is a passerby, I think Your Honor sort of adverted to this in the questioning of the appellants, that it would be a kind of a difficult task of line drawing to determine who's a passerby, who's entering, who decides suddenly that they see something on the display and decide to enter. The courts have abolished the distinction between invitees, licensees, trespassers. I think we would be treading back into that territory if we start trying to distinguish between passerby and customers for the purposes of determining duty. Certainly, that distinction is relevant in certain restatement sections that I don't think are applicable here. For example, in Restatement 40, the Section 40, it only applies to people who are on one's land. In Section 54, It extends only when a possessor's conduct introduces a new risk beyond the property. Again, as we would note, Dollar General here introduced nothing. The condition of the sidewalk pre-existed the building of the store. The defect was already there, it was controlled by the city, and even considering the modern restatement sections that have not necessarily been adopted by the Iowa Supreme Court yet, if you apply them faithfully with the commentary, they've reaffirmed the rule in Split Gerber that there's no duty beyond control. If we were to apply Section 54 the way the appellants urge it, it would essentially rewrite Section 364.12 and turn every shop owner on Main Street into a municipal insurer. And that was essentially the opposite of what Split Gerber attempted to achieve in creating certainty for business owners and municipalities in these circumstances. I see that I am out of time, so I will respectfully urge this court to affirm the district court. Thank you.
Just-
I'd like to address the question that you raised about what if it wasn't a crack, what if it was something else? One example would be a hole. For example, if customers in Dollar General are in the store and an excavator comes around to do utility work immediately outside the store and digs up the hole. And you can't see it if you walk right out the door, but it's there, and Dollar General staff knows about it. Do they have a duty to warn? Well, of course they do. They have customers in the store. They have superior duty. They have superior knowledge. Now, think about this in the context of the Mostert case, which I cite and quote from in the reply brief. Think about what happened in Wyoming. So the theater has knowledge that there's extremely dangerous flash flooding outside. It knows that. It does not warn its patrons, and they exit the theater so they don't take any protection and they die. So is there a duty to warn? In Wyoming, the Wyoming Supreme Court said, yes, there's a duty to warn. And they had knowledge, and they had superior knowledge, and there's no reason why that shouldn't apply in this case. Now, there's this concern about the sky is falling because this is going to be extensive and go beyond the immediate issues. You have a case in front of you which involves a defect immediately outside the front door of a store where the company knows about it, the owner knows about it, and affirmatively acts to funnel its customers right over there, that danger, doesn't warn. But also, the injured person, Mr. Clemen, literally falls and lands on Dollar General's property, and the injury takes place on Dollar General's property because he hits his hand into the door, into the sliding glass door. This isn't a sky is falling issue, and in any event, I think the court in Morris, the Iowa Supreme Court, said, we're not going to extend this to unlimited circumstances. This duty is going to be limited to time and place. I mean, there are limitations on how far it can go.
Agree with your colleague that the question of whether Dollar General actually funneled people over that that defect is not as clear as you are making it out to be?
Well, first, I think it is very clear because you can look at the photos. We put the photos in the brief. There is good concrete on each side of this maybe 4x4 square that's defective, and on that good concrete, they put displays. It's also in the testimony in the record. But also, what did Dollar General do immediately after Mr. Clemen fell? They removed those displays, and then they painted the concrete. Now, this argument is being made for the first time on this appeal. This argument was not made below, that there was in fact no funneling. And in fact, Judge Norman, in his ruling, went to great length to explain how Dollar General, in fact, funneled people he found that Dollar General funneled people into the store with these display racks and that they could have moved the display racks, and they did in fact move the display racks. He said they arguably exacerbated the risk with this conduct. Now, whether it happened in fact for this court's determination, this court has to read the record most favorably for my client, and Judge Norman found that to be adequate. He just didn't take it to the next step, which is he conflated risk of a cracked sidewalk with all risk, because there is risk from failure to warn, there is risk from failure to protect, and the restatement talks in terms of risk, and so does the Iowa Supreme Court. It talks in terms of risk rather than the defect. So the defect can create risk from tripping risk. For example, a pedestrian that's walking by can trip on it, but there can also be risk from failure to warn. Had Dollar General warned and protected, there would be no risk from that sidewalk problem, because that's in fact what they did. After Mr. Clemen fell, they painted around it with orange paint that they got for $5 at the hardware store. And then they barricaded around it with cones. They simply barricaded, and they put some of those cones on their own property. They didn't have to go on city property to barricade around that risk to protect their customers. So they had the ability to do that, and when they did that, they eliminated all risk from that because you could not encounter that sidewalk. Thank you.
Thank you to both counsel for your very helpful, responsive arguments today and the good briefing in this case. We will